Sutherland versus Labrador. Sutherland is engaged in business process outsourcing, BPO, and hired Labrador as its call center agent. Sometime in 2008, one of Sutherland's customers complained that Labrador initially asked for her credit card account, but only for purposes of verification. As it turned out, a second account was created and a new order was placed under the same customer's name. Thus, two sets of packages were shipped to the customer who had to pay twice for the same product. Under Sutherland's employee handbook, Labrador's action is classified as an act of dishonesty or fraud. Sutherland sent Labrador a notice to explain in writing why he should not be held administratively liable. Labrador committed several other infractions. As early as 2007, a red flag document was issued against Labrador for not disclosing customer information appropriately and signing up the call-in client for a second account without even verifying if he already had a previous account. The offense was punishable by a last written warning. In 2008, another red flag document was issued because Labrador created two accounts for a customer without informing the latter that she would be billed twice. Later on, the client complained. After investigation, a recommendation was issued finding Labrador guilty of violating the employee handbook due to gross or habitual neglect of duty. Labrador requested for resignation instead of termination. Thus, due to humanitarian purposes and his stay and contribution to the account, Sutherland allowed his request. However, Labrador filed a complaint for constructive illegal dismissal before the NLRC. Issue: whether Labrador was illegally constructively dismissed. Ruling: the Supreme Court ruled that the power to dismiss an employee is a recognized prerogative inherent in the employer's right to freely manage and regulate his business. The law, however, in protecting the rights of the laborers, authorizes neither oppression nor self-destruction of the employer. The worker's right to security of tenure is not an absolute right, for the law provides that he may be dismissed for cause. Furthermore, Article 282 of the Labor Code provides that an employee may be terminated from the service on just cause. The failure to faithfully comply with the company rules and regulations is considered to be a just cause in terminating one's employment, depending on the nature, severity, and circumstances of non-compliance. Labrador himself admitted his faults. These incidents were properly recorded and were properly discussed in Sutherland's recommendation. But before Sutherland could finally pronounce its verdict, Labrador submitted his resignation letter, impelled no doubt, as Sutherland alleged, by the need to protect his reputation and his future employment chances. Even if Labrador had not submitted his resignation letter, Sutherland could still not be held liable for constructive dismissal given the existing just cause to terminate Labrador's employment. Case dismissed.